Hello, everybody. Welcome to Oxford. Welcome to the Refugee Study Centre. It's a great pleasure to introduce our speaker today, Jane McAdam AO, Scientia Professor of Law and Director of the Andrew and Renata Kaldor Centre for International Refugee Law at the University of New South Wales in Sydney. With over 13 books and over 70 peer-review articles, it's fair to say that Professor McAdam has published extensively on all aspects of international refugee law, its contents, its workings, and its institutions. Professor McAdam has a keen interest in the global history of refugee and migration law and the refugee regimes. But one of the ways in which her research has been path-breaking is through its engagement with the effects of the climate crisis, both in the Pacific region, but also globally. Professor McAdam has been awarded a prestigious Laureate Fellowship for her project on evacuations, a project which will incorporate the perspectives of affected communities to provide the first sustained and integrated analysis of evacuations across a range of countries, regions, and contexts. Thank you very much for joining us today, Professor McAdam.
Thank you so much for having me. It's a really great honour and pleasure to be, well, at least virtually back at the Refugee Studies Centre, which is a place where I've spent many happy, well, I lived in Oxford, so times, I suppose, is what I would say. And thank you, everybody, for joining today. For those of you in my time zone, if you've managed to tear yourself away from a Valentine's Day dinner, thank you so much. And for those of you who have decided to stay, you can watch this later on. As Catherine said, I'm going to talk to you about evacuations as a form of displacement. And really, I suppose where this, or how I alighted upon this new area of research was something that really grew out of the work that I've been doing for the past 15 plus years now on displacement, migration, and planned relocations in the context of climate change. And it occurred to me that as contemporary crises intersect and compound, we are, of course, seeing record numbers of people on the move, people seeking to escape the harmful impacts of disasters, of conflict, of climate change, and other humanitarian emergencies. In 2022, there were more than 32 million internal displacements linked to disasters. And what struck me was that the fact that many of them, in some years, most of them, began as preemptive evacuations led by governments. In China and Bangladesh, for example, in recent years, there have been large-scale evacuations of 2 million people at a time, 5 million people at a time. Although smaller in size, recent catastrophic floods and fires in places like Australia and the United States have also seen unprecedented numbers of people being evacuated. When it comes to evacuations from conflict, we only need to look at the news for contemporary examples. Israel has again told millions of Palestinians to evacuate to avoid an impending ground invasion. In 2022, Ukraine ordered thousands of people to evacuate their homes because of conflict. In 2021, the Taliban resurgence saw many governments evacuating their own citizens from Afghanistan, as well as some Afghans, mainly those who'd assisted their military forces, but also some others. Meanwhile, the plight of stranded expats during COVID-19 renewed debates about whether or not governments have a duty to rescue their citizens. In all of these contexts, evacuations can be a life-saving emergency measure to move people away from imminent harm. But they can also displace people, often for prolonged periods and at great social, personal, and economic cost. Unlike the related fields of displacement, migration, and planned relocations, which are already distinct areas of study, policy, and to some extent law, evacuations have escaped systematic scrutiny, both in scholarship and practice. And it was my feeling that they tended to be viewed somewhat uncritically as a benevolent tool to rescue people from danger. And of course, you know, they can do that, but not always. And so in light of this kind of benevolent view, for instance, the Internal Displacement Monitoring Centre observed that because evacuations have, and I quote, successfully reduced the number of people killed in a number of large disasters, they highlight the fact that not all displacement is negative. And similarly, the Internal Displacement Monitoring Centre regarded Bangladesh's high number of preemptive evacuations in 2019 as, I quote, testament to the government's efforts in preparedness, allowing them to evacuate and saving many lives. Now, my concern is that this life-saving framing has led to a research and policy blind spot. In fact, creating a risk that the needs and rights of millions of evacuees will remain invisible and unaddressed. If law and policymakers don't see the displacement aspect, then disaster prevention and preparedness strategies may be ill-targeted and costly, and people's protection needs may become overlooked. As Catherine mentioned in her introduction, I was recently awarded a 5-year Australian Research Council Laureate Fellowship to undertake the first sustained integrated analysis of evacuations across multiple countries and contexts. This research program, which will allow me to establish a team of postdoctoral and PhD researchers, will investigate how evacuations are understood, how they're governed and resolved as a matter of law and public policy. Drawing on a vast array of literature and practices over time, ranging from situations of conflict to disasters, pandemics, and other humanitarian crises, the research program will try to determine whether or not there is a unified concept of an evacuation, and also whether there are common principles underlying when and how evacuations are used. And the first question, I suppose, that we need to grapple with in establishing this research program is, what is an evacuation? Despite their widespread use, evacuations are, as a concept, very imprecise. There's no uniform no uniform definition of an evacuation. And in the media and general discourse, the term is used to describe a vast array of practices with different legal underpinnings that range across different legal, or in the area I'm particularly interested in, different international law subfields, including refugee law, human rights law, disaster law, international humanitarian law, trafficking, inter-country adoption, and consular protection. We therefore have a very incomplete understanding of how legally to classify evacuations. Are they a form of rescue, a form of displacement, de facto relocation, forced retreat, humanitarian assistance, consular protection? Maybe they're all of these things, but we haven't really examined that in any detail yet. When, why, and how are evacuations used? What legal standards should govern their conduct? And importantly, when and how do evacuations come to an end? As I've already highlighted, evacuations can save lives. They can help citizens to return home. They can enable refugees and would-be refugees to access protection. Evacuations can be spontaneous or assisted, voluntary or forced, violent or peaceful. While they typically occur within countries, some do take place across international borders, and they're usually a form of consular protection, so repatriation of citizens from conflict or from pandemics, or in that case, they can be a form of humanitarian assistance to non-citizens to get people out of harm's way. In contrast to permanent relocations and forced or managed retreat, evacuations are generally meant to be rapid and temporary. But again, as I start to look at historical practice, that's not necessarily always the case, even in the planning of an evacuation. They normally also envisage safe and timely return. On occasion, they might instead be used to get refugees out quickly so that they can be processed somewhere else. And as I'll come back to, in the disaster and climate context, return may not be possible. So then what happens? I mean, in the conflict example as well, but the focus so far of my work has been on the disasters and climate context. So despite their ostensibly protective function, evacuations can constitute arbitrary displacement, uprooting people and even amounting in some cases to unlawful forced transfers. In armed conflict, likewise, they can protect civilians from harm, but they can also mask forced transfers in violation of international humanitarian law or fail to protect those most in need, particularly if people can't move. In disasters triggered by natural hazards and amplified by climate change, evacuations can be a vital rescue tool, but they can displace people for prolonged periods of time and also result in rights violations. As I touched upon a moment ago, there does seem to be a common assumption that evacuees will eventually be able to return to their homes. And in fact, the assumption seems to be that it will happen quite quickly. But we know that that's not necessarily true. Now, there's certainly evidence to suggest that displacement in disasters is less likely to be protracted than displacement arising from persecution or conflict. And if we look at the Internal Displacement Monitoring Centre's figures on the number of displacements and evacuations in a year, and then the number remaining at the end of the year, that is quite telling in terms of the reduction of those figures in the disaster context. But at the same time, there is a large data collection gap, which means our knowledge is incomplete. And particularly, we have a gap when it comes to disaggregated data showing the impact on particular groups. A scoping study by the Internal Displacement Monitoring Centre in 2015 concluded that there are probably many people living in protracted disaster displacement who got there because of evacuations than was previously thought. We also know, and particularly as climate change amplifies the impacts of disasters, that a substantial number of people can't ever return. And some can never really find a durable solution anywhere or for a very long time. And of course, that has serious consequences for people's lives, livelihoods, legal status, and general well-being. Part of the challenge, and this kind of comes back to that seeing evacuations as displacement point, part of the challenge is this invisibility of the issue. So people who are evacuated and then are stuck may simply be described as people who are homeless or the urban poor, some other kind of term applied, rather than being identified as internally displaced people whose needs are understood within a rights-based framework. And I think that in turn has really significant implications for people who remain displaced but don't get counted, and therefore responsibility for protection and assistance also it becomes a bit of a blind spot. Even if physical return is possible, people's economic circumstances might mean that they're exposed to the same risks as before and therefore remain at risk of future displacement. There are many stories about people who return after a disaster to live in a tent in their front yard, in the Australian context as well. After very significant flooding, we've still got people, and the bushfires some years ago, we've still got people living in temporary shelter. In the floods context, there are countless stories of people who've gone back to live in their house, but the house is barely habitable. So it's mouldy, that causes health issues. And of course, that exposes people to greater risk of illness and future extreme weather events. So even though people might return, they haven't actually found a safe, dignified, or durable solution. And continued exposure to hazards can further increase their vulnerability over time. It's also important to note that very often these are people who are already facing intergenerational disadvantage and marginalisation. So there is a compounding effect there as well. So far, I've done some background work on Australia's legal frameworks concerning evacuations. And the detailed legal analysis I did there of, sorry, I should backtrack a little and say Australia is a federation with states and territories and then a Commonwealth government. So looking across all those different areas, a detailed analysis reveals that current legal and policy frameworks pay insufficient attention to protection needs that might arise in an evacuation, particularly for groups that might find themselves in vulnerable situations, such as children and people with a disability, as well as people who are displaced for prolonged periods. And I found it really striking that none of Australia's national or state or territory legislation or guidelines engages directly with international law or standards, nor with domestic human rights charters that exist in Victoria, Queensland, and the Australian Capital Territory. Perhaps even more revealing was the fact that official reports, reports of official inquiries into the 2019-2020 bushfires and the 2022 floods that we had make no explicit mention of human rights, either in terms of identifying rights at risk or holding authorities to account. It could be said that international legal standards are implicit in some domestic guidance on evacuations in Australia, but my sense is that more overt references and detailed analysis would give much greater prominence to and awareness of the human rights obligations that authorities are required as a matter of law to respect. It would also provide greater measures of accountability. So in my view, at the very least, state, territory and federal guidelines on evacuations should acknowledge and reflect Australia's obligations under international law and underscore the importance of responding to evacuations within a human rights framework. One particular weakness that I noted in Australian frameworks was the lack of attention given to the unique needs and rights of specific groups. I mentioned to children and people with disabilities. While some of Australia's evacuation policies recognise children as a vulnerable group and or suggest that a child-sensitive lens should be adopted, there is very little detail as to what that actually means. And that's despite the fact that under international law, the best interests of the child must be a primary consideration in all actions concerning them, and states must ensure that a child has such protection and care as is necessary for their well-being. The needs of people with disabilities are similarly overlooked, again, despite Australia's well-defined obligations in international law. The Convention on the Rights of Persons with Disabilities, for instance, says that states must take all necessary measures to ensure the protection and safety of persons with disabilities in situations of risk, including situations of armed conflict, humanitarian emergencies, and the occurrence of natural disasters. Yet, as with children, disability is mentioned only as a risk factor in the Australian context. There is no reflection at all of the active participation and agency of people with a disability. So with that kind of backdrop, I just want to come back to why do I think there is this research gap, given the nature and scale of evacuations. I find the absence of deep conceptual work or indeed detailed empirical analysis of evacuations in the forced migration scholarship puzzling and concerning. And in an article that was published some time ago now in the Refugee Survey Quarterly, I put forward some possible explanations. So the first one is this idea that evacuations are often seen as a proactive measure to move people to safety in the face of an imminent threat rather than as a form of displacement. So there's that kind of framing, conceptual perspective issue. The other point is that since people might evacuate on their own initiative rather than being formally moved, and in fact, in most cases, people are making their own way somewhere, they might not be formally recognised or counted. And that's certainly the case if people go and stay with relatives or friends rather than going to an evacuation centre. And the idea too is certainly in the Australian context, you don't want people staying in evacuation centres. That's really an initial place to go, but after that, it's getting people out and kind of triaging people. Although the guiding principles on internal displacement recognise that evacuations are a form of internal displacement, they won't constitute arbitrary displacement in a disaster if the safety and health of those affected requires their evacuation. That said, though, planned relocations and migration can also constitute preemptive protective measures. So I think this kind of preemptive bit doesn't really alone account for the comparatively sparse literature on evacuations in the forced migration context. So the second reason that I identified was perhaps what I've called the chicken and egg problem. The data doesn't really let us, at this stage anyway, make a clear distinction between preemptive evacuations and displacement in response to disasters, which perpetuates this lack of conceptual clarity and may also make quantitative analysis quite difficult. Accurate data is vital to planning, to improving responses, and to also enabling the meaningful participation of various groups in planning and designing support programs. So when does a preemptive evacuation, which may be voluntary, become arbitrary displacement? Added to this is the fact that evacuations may sometimes be very short-term and geographically confined. People also might be evacuated multiple times from their home if there's recurrent flooding. And all these elements, I think, might challenge traditional conceptions of what displacement looks like. A related point is that domestic authorities are primarily responsible for carrying out evacuations, and it may be that officials simply don't conceive of that kind of movement as displacement. Perhaps if more international actors were involved, then the framing might be different. The third and related point is the fact that academics writing in this field, that is in the field of forced migration, refugee studies more broadly, are often eager to produce policy relevant research, and Oliver Bakewell has written extensively about this. This so-called dual imperative has been described as a common characteristic of refugee law scholarship, which is an area that is heavily influenced by international organisations and practitioners who are actively taking part in scholarly outputs and the production of knowledge as well. While there are certainly enormous benefits of a closely connected academic and policy community, there can be drawbacks as well, including that at times having the opportunity to influence may stifle deeper reflection or critique. On the flip side, if policymakers don't prioritise, not on the flip side, related to that is that if policymakers don't prioritise certain categories of inquiry, such as evacuations, then researchers might overlook them as well. And this is where Oliver Bakewell argued that by adopting the classifications and priorities of policymakers when formulating their own research questions, academics may privilege a policy-relevant worldview and thereby render other groups of forced migrants invisible. So in the evacuations context, I would argue that the absence of detailed conceptual analysis of evacuations has resulted in a large knowledge gap, impeding optimal standard setting. It's also led to fragmentation in practice. The fact that multiple legal subfields are involved across conflict and disasters and so on means that multiple international agencies, multiple government departments are engaged, but they also typically lack coordination, notwithstanding these common objectives and challenges. And that in turn hampers access to information, which has stark implications for law and policy development. And as I've noted already, without clear data, authorities just can't plan and respond sufficiently. So in terms of the 5-year Laureate project that I'm embarking on from the middle of this year, what's it going to do? What are the objectives and the ambitions that I have for it? Well, it has a number of broad aims. And the first one is to reorient the orthodox starting point for evacuations, that rescue paradigm, by hypothesising that while evacuations can indeed be life-saving, they can also displace people and undermine longer-term protection needs. And so from this perspective, evacuees aren't simply passive recipients of humanitarian assistance, but rather they are rights holders with legal entitlements. So human rights law then provides an analytical framework for determining who is evacuated and why, and how human rights are and should be safeguarded at all stages of the process. under human rights law, states must respond to threats to life and limb occasioned by natural hazards, including the adverse impacts of disasters and climate change, which may include an obligation to evacuate people at risk, including sometimes by force. In the Briddick case, the European Court of Human Rights found that the right to life had been violated when an evacuation order had not been properly implemented, and as a result, people were killed by a mudslide. And here the court said this was because local authorities, first of all, had failed to monitor the area where it was known that mudslides could occur, and therefore they were unable to properly inform and warn people who might be affected. Further, they only ordered an evacuation once a first and non-deadly mudslide reached the town. And then they failed to stop people from returning to their homes the next day, where some people then were killed by a second bigger mudslide. As well, the authorities were criticised for failing to do disaster risk reduction, to put in place measures that might have averted the mudslide or made it less severe than it was. And they were also criticised for not installing an early warning system to allow for timely evacuations. So the second aim of the Laureate project then is to elucidate when do states have a duty to evacuate, how is it circumscribed by human rights law, and also when is it owed extraterritorially. So this will clarify the scope of states' obligations to ensure that people are properly assisted and neither subjected to arbitrary displacement nor left to fend for themselves. It will also examine that kind of temporal space between short-term and maybe recurrent evacuations and longer-term ones that may actually morph into a de facto relocation where people may be caught in a legal limbo without sustainable or durable solutions. Thirdly, a cross-cutting methodology aims to generate comprehensive and comparative insights into evacuations from a diverse range of factual and legal settings, from different jurisdictions, historical periods, actors, including affected communities, thereby enabling a cross-fertilisation of ideas from traditionally siloed contexts. As part of that, the research will seek to map and compare laws and practices across 4 instructive case study countries, 2 from the so-called Global North, 2 from so-called Global South. So Australia and the US, Global North, Fiji and Bangladesh, Global South. They have vastly different resources and contexts, but all of those countries have extensive experience of evacuations in different forms, whether that be evacuating nationals, non-nationals across international borders, whether it be the disaster context, the conflict context. There's a whole range in there. The project won't only look at those 4 countries, but they're the ones that will have a kind of clearer in-depth focus. The project will look at both international and domestic legal constraints on government power to execute evacuations, and will also consider what special legal duties states owe people in particularly vulnerable situations. So that's drilling down then into people with disabilities or people of a certain age or gender or whatever it might be, not presuming that people are automatically vulnerable, but rather interrogating when and how vulnerabilities might arise. So fourthly then, my hope is that the research program as a whole over this 5-year period, with what comes out of it, will enable legal and policy change by articulating conceptually clear and empirically grounded principles to ensure that evacuees' rights are respected and protected before, during, and after movement. Finally, I think since evacuations are generally seen as a measure of last resort, although even that is now coming into question as we are seeing more frequent, more severe disasters amplified by climate change, it's absolutely vital that authorities undertake a holistic assessment of the hazards facing people living in at-risk areas. Evacuations are generally envisaged for emergencies when people are at imminent risk of harm. But I think as a matter of good public policy, there needs to be far greater consideration of situations where risk may materialise over a longer period of time, or where, you know, in the context of climate change, slower onset impacts exacerbate the impact of sudden onset events. And I think it's quite remarkable but sobering as well to realise that at the moment, only 3% of disaster funding is spent on preparation versus 97% on recovery. And that divide seems to be mimicked very often in national contexts as well as at the international level. And this is despite the fact that the UN has estimated that every dollar spent on preparation could yield a 60-fold return. And if you think of that over time, the compounding effect that could have. Of course, continued exposure can increase vulnerability over time as well, which is why coordination, foresight, and planning is so important. Even a brief evacuation can have long-lasting, lifelong impacts, affecting different rights and well-being over time. So I think we also need to keep in mind that physically moving people out of harm's way is only part of the evacuation process. Ensuring that people can return or relocate in safety and with dignity is crucial to recovery and to realising the right to life in its fullest sense. Thank you for your attention. I'm very happy to take comments or questions that you might have.